Greetings, welcome to episode 16 of the Video on Demand series. My name is Prince Amtiri, an investigator in the Directorate of Restrictive Business Practices at the Competition and Consumer Protection Commission in Zambia. I've been with the Commission for over a year, and before that I was with the Ministry of Commerce, Trade and Industry. Today we are looking at the leniency program, which is anchored on Section 79 of the Competition and Consumer Protection Act number 24 of 2010 as amended by Act number 21 of 2023. So leniency program refers to a program which aims at encouraging enterprises to self-report themselves to the Commission and their participation in a prohibited agreement or conduct, and then in turn get to benefit a waiver on the penalties that would have otherwise been applicable to them for participating in a prohibited conduct. These penalties that are waived off, they include on one hand administrative fines that are on the civil side of the applicable penalties, and then there are also criminal sanctions that apply, in which case entities or persons involved in such conduct may be prosecuted. So the agreements that are looked at or considered are those that are prohibited, and there is no justification that would be provided whatsoever for existence of such agreements. On the horizontal side of the agreements, we are looking at Section 9 of the Competition and Consumer Protection Act, which provides for the types of horizontal agreements that cannot be in any way justified for their existence. Specifically, Section 9(1)(a) speaks to agreements that aim to set prices or set trading conditions among enterprises that are purely aimed at increasing the benefits for the enterprises and at the same time eliminate competition among them. So the agreements that are prohibited under the Act are those that have no justification whatsoever, and an applicant who is found wanting or engaging in such agreements would be penalized. So for an applicant who wishes to have their fines reduced or receive immunity against the fines, they would then be able to come through to the Commission to apply for the leniency program. What the leniency program does is it allows an enterprise that has been party to a conduct or an agreement to state their participation and then provide evidence to the Commission that allows to prove the existence of that agreement which is prohibited. And in doing so, they also have to pledge and agree to cooperate throughout the entire process of investigation that the Commission is carrying out. And when they provide that information and they provide evidence, then the Commission should be able to conclude that investigation using that information that has been provided. I must mention, this is information which the Commission should not have already had in its custody. So someone who comes to bring this information, they will obtain a marker for their application at the time when they apply. And this marker allows the applicant to know that their application has successfully been received by the Commission, and also it places this applicant in a queue for those who would wish to apply for leniency. And also it allows the Commission to also put a tag on that application in order for the Commission to arrange the order in which the applicants have brought forward their applications. This is very important because the one who applies the first or gets the first position in the queue of applications would then stand a chance to have immunity from the fines in totality or the criminal aspect of it. And then those that follow in line would also have a chance to have their fines reduced. But then that also depends on the quality of information they produce or bring forward to the Commission. This has to be information that significantly adds value to the already provided information and allows the Commission then to prove existence of the agreement or conduct in the markets. I must also mention that the evidence required may differ depending on the type of agreement, because we have horizontal agreements and then we have vertical agreements that are prohibited. For vertical agreements, we are saying these are agreements between enterprises that are in the same line of distribution but at different levels. You are looking at maybe one is a manufacturer and then the other one is an authorized distributor. And particularly the law prohibits resale price maintenance in instances where one is a manufacturer and the other one is a distributor. The one who manufactures products cannot set a particular price or prescribe methods of pricing for the one who is in the downstream market, who is the distributor of the products to the open market. So those that are involved in such an agreement would need to provide evidence relating to the conditions that they've agreed upon on the pricing of the products as they are being distributed. Then for those in the horizontal market, these are actual competitors. They are selling substitutable products or competing products, and ideally consumers would then be able to switch one product for the other. And these agreements have to do with agreeing among competitors not to compete, either by allocating markets or setting prices together, or being involved in bid rigging as the case may be, or collectively refusing to deal with a particular client or customer. The applicants of the leniency program have to ensure at the time they come to apply, they have information that relates to their participation, they have information that relates to the existence, the length of period of time in which this agreement has been in existence, and also they have information relating to the entities that are also participating in this agreement. These would be then the address of the participants. It would also be the contact people or the official address for these people that are participating in the conduct that is prohibited. Again, the one who's applying for a leniency program has to make sure they are able to demonstrate or provide information that specifies the kind of products that have been targeted and what the aim of those agreements were, particularly for those products, if it was to set prices or to allocate markets. And also, the person who applies to the commission has to make sure they are able to accurately explain the geographical location of the markets that they've been involved in, or where this agreement has been taking place from. And then when they are doing the application, they have to address that application to the executive director, and they have to do that application as soon as is practical in order to secure their place in the queue of potential leniency applicants. I must also mention the people who qualify to submit an application on behalf of an organization has to be someone who is in a position of authority. It could be the executive director or even the company secretary, because these are representatives of the company. And at the time they are submitting that application, they have to expressly state that they are doing the application on behalf of the organization that they are representing. In instances where someone who does not have that decision-making authority in an organization provides information to the commission, it will be treated as whistleblowing. For instance, if a security guard provides information to the commission relating to the agreement that exists, because that security guard is not in a decision-making position at the institution, they will not be regarded as having submitted an application on behalf of the organization, but it will be treated as whistleblowing. So speaking about who qualifies for applying for an organization, a leniency applicant can be the chief executive officer of the organization, or it can be the company secretary or someone in a decision-making position. And this is someone who has to be able to speak for the company regarding that application. And then they must expressly state that they are making an application for the organization that they are representing. In instances where it's a group of companies, they have to indicate that they are making an application for the entire group of companies, and they have to state the members of that group so that then the application covers for everyone who is stated in that group. And also, the one who applies cannot be someone who just works as an employee, such as a security guard, because such a person does not have the decision-making authority in the organization. And because of that, the information they provide will be treated as whistleblowing. And then for the person who applies, they also have to indicate the information relating to the parties that are party to the conduct or that are involved in the agreement that is being reported to the commission. This includes information relating to their names and their place of business, their addresses. And they also have to provide sufficient information to prove the participation of other players in that agreement. And they also have to state the product being dealt with and also the aim of the agreement in relation to that product. They also have to provide information relating to the geographical map or location where this agreement was intended to or was being implemented, and the duration of the agreement in existence, and the stages at which each one of the other members joined the agreement. In instances where possible, they can also provide information relating to the market shares of other companies that may not be party to that agreement or conduct, in order to help the Commission to appreciate the extent of the product market and the competing products in that market. The applicant should also guard against providing misleading information or information that is inaccurate or concealing information, as this would risk having their leniency program revoked. The Commission reserves the right to revoke the leniency program at the time it determines that the information that was provided was falsified or was inaccurate, or it was misleading or intended to mislead the investigation. And again, the Commission also reserves the right to revoke the leniency program where it determines that the participant in that agreement who has provided this information was actually concealed as an instigator of the agreement, but opted to come to the Commission and conceal that information that they were the originators of that agreement. And then when they are applying this for this leniency program, if the parties have operations in other countries as well, they may state in their application that they do have operations in other countries and that these operations, they are also being investigated, or if they have applied for a leniency program in other countries as well. Notwithstanding, their application in other countries for the leniency program does not in any way affect their application in Zambia. And even when they've applied for leniency in Zambia, they ought to consider applying for leniency in other jurisdictions as well if they engaged in similar anti-competitive conduct in those jurisdictions and the leniency program is provided for in those jurisdictions. And then also on the aspect of having multiple or simultaneous applications, the Commission will consider which application has information that sufficiently lessens the burden of carrying out the investigation and proving the existence of that agreement and conduct. And also, the applicant, when they have made the application successfully, they have to ensure that they are given a marker for the application, which stipulates the time when that application was made, and also the articles of evidence that have been submitted to the Commission at that time for the Commission to carry out investigations into that agreement, which is prohibited. And also, the applicants to a leniency program, even if they have their fines waived off or they've received immunity against prosecution, they ought to know that they may still face private damages or can be sued by third parties, because the Commission's leniency program applies to the penalties that are provided for in the Act and in relation to the conduct that has been established. And there may be third parties that may wish to pursue compensation in court who have suffered harm due to the agreement that was put in place. And the parties to the application must also know that their application to the Commission will be considered and they will be given a waiver depending on the time when the application was lodged and also the information that they've provided. Thank you so much. We look forward to the next episode.